Okay, Attorney Nate Amendola here. The question is, what is a preliminary hearing in Massachusetts criminal law? The truth is, there really is no such thing as a preliminary hearing. What people often are referring to when they mean a preliminary hearing is a clerk magistrate's hearing or a probable cause hearing. Those are essentially the same things, serve the same functions, although at two different times. So let's break this down. What is a clerk magistrate's hearing? A clerk magistrate's hearing is a hearing with the defendant, usually the police prosecutor from the municipal police or the state troopers, and your lawyer, if you choose to bring a lawyer, and a clerk magistrate. At that hearing, the clerk magistrate will hear some evidence, usually in the form of testimony from the police prosecutor, and the police prosecutor can be, and oftentimes is, subject to cross-examination, and the magistrate will listen to all the evidence and then determine whether there is probable cause to charge the defendant with the crime. Probable cause is essentially the second lowest standard in criminal law, the lowest being reasonable suspicion. One level above that is where we are, probable cause, meaning is there sufficient, reliable, trustworthy information such that a reasonably prudent person would believe that you were the person that committed the crime and a crime has been committed. It's a very low standard. It's the same standard the police have out in the field to make an arrest. If the clerk magistrate determines that there's sufficient probable cause, then one of the things that he or she can do is issue the complaint. If the complaint issues, then at a later date, you are going to go to court for an arraignment. A probable cause hearing is a little bit different. That's if the case is already in the district court and the Commonwealth is contemplating an indictment or bringing the matter to superior court. Usually that's in the form of an indictment that comes from grand jury, but sometimes there's this mechanism in criminal law, or the district court, I should say, where a hearing can be held in the district court. Witnesses will be presented, there'll be evidence, and then the judge will be making a determination whether there's sufficient probable cause to bind the case over to the superior court. That is what people mean by preliminary hearings.